How to initiate arbitration. Are you facing a dispute in real estate, investing, and wondering how to initiate arbitration? You're not alone. Many investors encounter conflicts during home buying or property transactions. Let's break down the steps to get you started on the arbitration process. First, check your purchase agreement. Look for an arbitration clause. This clause indicates that any disputes must be resolved through arbitration instead of going to court. If both parties sign this clause, arbitration is typically required. Next, you will need to submit a formal document known as a demand for arbitration. This document should be filed with the arbitration service mentioned in your contract. In this demand, include a description of the dispute and attach a copy of the arbitration clause. You will also need to pay a filing fee, which can vary depending on the arbitration service. Once you file the demand, the arbitration service will notify the other party about the dispute. They will provide a deadline for the respondent to respond. This step ensures that both parties are informed and can prepare for the arbitration process. After that, it's time to select an arbitrator or arbitrators. The parties can mutually agree on an arbitrator or follow the procedure set by the arbitration service. Often, the service will provide a list of qualified arbitrators who have experience in real estate matters. You can rank your preferences or eliminate candidates from this list. An initial hearing usually takes place next. This preliminary hearing sets the framework for the arbitration process. During this meeting, timelines, evidence exchange, and hearing dates are established. This organization helps clarify any procedural issues before the main hearing. When the arbitration hearing occurs, it is generally less formal than a court trial. Sometimes, the hearing might even take place at the property involved in the dispute. Both parties will present their evidence and arguments to the arbitrator, who will then make a binding decision. Keep in mind that arbitration costs can vary. These costs may be split between the parties or assigned to the losing party, depending on the contract or the arbitrator's ruling. Unlike court litigation, arbitration fees can add up, so be prepared for this financial aspect. Finally, remember that arbitration decisions are usually final and binding. There are very limited grounds for appeal. This means that you give up the right to sue in court over the same dispute. Understanding the arbitration clause in your purchase agreement is essential before you agree to it. For real estate investors, arbitration can be a quicker and more private way to resolve disputes compared to traditional litigation. By following these steps, you can initiate arbitration effectively and keep your investment activities on track.